Good to go? Good to go? Can you hear me? All right. Okay, let's get back to work. Now we're going to do the 02 class out of, 26 or 27, and we're now moving into the first question for the 10 questions that you ask about any piece of evidence, and this has to do with relevance. And we're going to spend most of our time talking about materiality and what materiality means, but we'll also introduce the concept of logical relevance, and hopefully we'll have time to get to two clips. One is the something you may recognize because of the actors involved, the Brockovich case, and another one which is something more obscure. It was a program called Crime and Punishment that Dick Wolf produced. He's the producer of Law and Order, and it was actual criminal cases in San Diego County. So it was edited in a very slick fashion, but it was real lawyers in criminal cases, and it provides some really fascinating teaching material. So, sorry about that. So here's what we'll do. We'll talk about Rule 401. We'll define materiality, which we'll see as part of 401, and we'll talk about what is logical relevance. Now here I'll talk about a case, Fleming V Larson, which I dropped from the additional reading packet. It was in there last year. The reason I dropped it is you don't really need to read it. I can just describe it to you. It's basically just a case where the plaintiff wanted to offer evidence that the defendant was speeding, not at the time of the accident, but some miles west of the accident. And it provides a nice way to think very carefully about what logical relevance means. We'll then talk about a distinction that actually has less legal force than lay people often assume. Oftentimes you'll hear, oh, he was convicted of nothing but circumstantial evidence. And that sounds weak, right? Circumstantial isn't as good as direct evidence. Actually, circumstantial evidence, particularly with modern-day scientific methods of proof, is often, if not usually, more persuasive. Because direct evidence, as it turns out, will be eyewitnesses to the crime, whereas circumstantial evidence will be things like DNA identification evidence. What I'll do is define for you direct and circumstantial evidence, and you'll see how you can define it in terms of logical relevance. We'll then move to 402, which is, for the most part, a quickie. It basically says relevant evidence is admissible, but it allows us to think about the legitimate sources for evidence law. As I mentioned before, evidence is unusual in that it is very codified. There are clear federal rules of evidence. Common law is largely unimportant. Well, to what extent does the common law even matter anymore? And what about state law? We'll talk about those issues. And then we'll do our relevance typos. Oh, now here's a slide mess up, so let me see if I can skip ahead. I thought I deleted that. Okay, here we go. Now again, I'm going to show you the rule. Don't write down the rule. If you need to take notes, if you don't already have it in your notes, when I say write, that's when you want to write. It's important to be obedient. Relevant evidence means evidence having any tendency to make the existence of any fact, and I put this letter in A. You won't find it in the original rule because it helps to break this up into A and B. That is of consequence to the determination of the action. B, more probable or less probable than it would be without the evidence. Okay. The first question you always want to ask is, what are you trying to prove? Right? That's always the first question, and it's definitely the first question in assessing relevance. You have to ask what you are seeking to prove in order to assess relevance because, as your textbook authors point out, relevance is what they call a relational concept. Well, what does that mean? You always ask relevant for what, right? It's relevant in terms of what you were trying to prove. That's why that's the first question. Once you ask that first question, or answer that first question, I should say, you then apply the first part of 401, which is X, that is what you're seeking to prove, a, quote, fact that is of consequence to the determination of the action. Now that's pretty heady stuff, so we're going to condense that language into something simpler. And then you want to ask B, does the evidence have any tendency to make that X more probable or less probable than it would be without the evidence? Okay. So once you know what you're trying to prove, you ask whether what you're trying to prove is an issue in the case. That's what that A part means. And then, once you've established whether X is in fact an issue that is of consequence to the determination of the action, you ask, does the evidence increase the likelihood of that X? Okay. Now, I introduced this structure yesterday, but you see here how it maps nicely onto 401. Now, this first part, A, is X a fact that is of consequence to the determination of the action? Another way of saying this is, does X matter? And that's a good mnemonic for remembering that this is the materiality aspect of relevance, whether X is consequential, whether X matters or not to an issue in the case. And this language under B, any tendency to make X more probable or less probable than it would be without the evidence, this is logical relevance. Logical relevance is an aspect of relevance, but it doesn't take over, okay? It doesn't take over. It's just one of the two bits. Now, Mueller and Kirkpatrick say that the term relevance now embraces both materiality and what I call logical relevance. But it's good to keep these two notions, logical relevance and materiality, distinct, because something can be material and not be logically relevant. And something can be logically relevant and not material. And you have to be both in order to be admissible. Okay? Now, before I give you examples of that, let's reiterate the test using the simpler terms. What is the evidence offered to prove? You call this X. Is X an issue in the case? If the answer is no, the objection is it's immaterial. If X is an issue in the case, materiality is not a valid objection. But if you don't think that the evidence actually increases the likelihood of that supported outcome, if the answer is no, then it's logically irrelevant. But if you've passed both tests of relevance, then, as we'll see in 402, you've passed the relevance test, and the evidence is presumptively admissible. Okay? Now, even by turning from the very arcane language of 401 to the more intuitive language of does it matter and is it logically relevant, this is probably still pretty abstract. So let's do a concrete example so you can see the issues of logical relevance and materiality. And this is the ARP that I took out because it's just as easy to tell you as to have you read this. Oh, I should mention that you've probably been pleased with how light the reading is. I do try to keep it down to a minimum, but I do assume that you then spend more time really thinking about the questions, particularly in the ARPs. I should warn you, though, that the readings aren't always this light. They do get substantially more heavy throughout the semester. So if you're trying to figure out time allocation, you probably should allocate a little more time for your future reading than you are now. Okay, so anyway, so here's the Fleming case. Albert Lawson is the plaintiff. He was a passenger in the car with Robert Fleming. A typical case where a passenger, probably a buddy, decides, well, my friendship is worth less than the amount of this lawsuit. The evidence at issue was testimony by a witness named Rager that Fleming, the defendant, was going 90 miles per hour, 33 miles away from the accident. Okay? This is the evidence. We're going to apply the relevance test. We're first going to say, well, what are you trying to prove? And then, if that's an issue in the case, we're going to say, well, is it logically relevant to make that proof? So let's first decide, what is the evidence offered to prove? Okay. Well, let's say that the plaintiff is sneaky. The plaintiff says, I'm going to get around the logical relevance problems. Okay? I'm going to get around the logical relevance problems because what I'm going to do is not ask the jury to infer anything. I'm just proving exactly what I say the evidence says. So here's what the plaintiff tries out. I'm just trying to prove that the defendant was speeding 33 miles away from the accident. I'm not trying to get the jury to infer that that means he was speeding at the time of the accident, because I know that's an inferential question and that involves some logical relevance issues. That's my issue. Well, notice what happens if you try to avoid logical relevance problems. Does it even get to first base? Is X an issue in the case? Is it an issue in the case whether the defendant was speeding at some other time and some other point? No. The question is, was the defendant speeding at the time of the accident? You can speed all you want, right? You can be a speeder, but if you weren't, unless you were speeding at the time of the accident, that's not negligence. So if the plaintiff tries to avoid logical relevance by saying, I'm not trying to get the jury to infer anything other than what the evidence directly proves, he loses on materiality. Okay? So you'd say, this is a piece of evidence that's logically relevant, because it just proves itself, but it's immaterial. Okay, most plaintiffs won't be so stupid. Most plaintiffs will acknowledge that they're trying to prove something other than what the evidence directly states. So they'll say something like this: what I'm trying to prove is that the defendant was speeding at the time of the accident, right? That's what I want the jury to conclude from this evidence of his speeding before the accident. Now we're saying something. So you apply your test. You say, well, is whether the defendant was speeding at the time of the accident an issue in the case? And you can say, yes, it is material because it goes to the defendant's negligence. Now, of course, you have to know something about the substantive law, right, in order to know whether something is material or not. And that's something Mueller and Kirkpatrick say is maybe the reason why we don't teach you evidence until the second and third year is you have some notion of the substantive law, underlying torts and contracts, and you can apply your understanding to now evaluate rules like materiality. But now we have the logical relevance question. Does the evidence increase the likelihood that defendant was speeding at the time of the accident? And if you stop and think about this, you realize, oh no, that's an interesting question. Assume I'm driving down the road going 90 miles an hour. How much more likely is it that 30 miles past that point at which I'm going 90 miles an hour, am I going to be still going 90 miles an hour? How certain can I be that someone is going to maintain their speed? Are there other things I want to know about that 33 miles west of the accident, right? Do I want to know about road conditions, about the speed limit, about the geography, about the mood state of the person? Notice that you start asking all sorts of questions when you start asking the logical relevance question. Well, let's not ask all those questions, because I want you to get a good general idea of logical relevance. Rather, let's think about this. If you're analyzing the logical relevance of this issue, does the evidence that you're going 90 miles per hour, 33 miles away from the accident, increase the likelihood that you were speeding at the time of the accident? How do you get from the evidence to the conclusion? What facts would allow you to go from the evidence to what you're seeking to prove? What facts would allow you to go from the evidence to the conclusion? Now, I'm going to break this down into two things, two different kinds of facts, because these two different kinds of facts are important in deciding what kind of logical relevance problem this is. As you'll see, it will help us distinguish between logical relevance and conditional relevance. Okay? We'll get to that later, but think about it this way. First, you might want to have specific evidence. There might be some other evidence that either the defendant maintained his excessive speed for 33 miles, or as a general rule, the defendant was very regular in the speed in which he drove. The speed in which he drove? Boy, that's the cold talking. He was very regular with respect to the speed at which he habitually drove. That's a lot better. Okay, keep that one. Let's edit out that other little bit. Well, the question then is there evidence that the defendant maintained his speed? Notice that in analyzing the logical relevance, if you're looking for specific evidence, you're really just asking for yet another piece of evidence. And you can imagine how you could get into an infinite regress here, right? Up to the point where you'd have to be proving the direct facts sought to be proved. So this is going to get you into trouble if this specific is necessary. What usually happens in logical relevance, though, is that the judge will exercise his common sense. The judge will say something like, well, I think it's relevant because if you're a speeder, you tend to stay a speeder, right? Speeders are speeders. So the fact that the defendant was speeding 33 miles away from the accident is some evidence. Remember, it only has to be a little bit of evidence. It only has to increase the likelihood by a tiny amount to be logically relevant. Then that will be true. Now, what you have to ask yourself is this a matter of common knowledge? And we'll read a case later, a few days from now, where common knowledge becomes not so common. But the bottom line is, if either the road from E to X is through some specific fact that is proven, okay, or as a matter of common knowledge that speeders tend to speed regularly, then the evidence is logically relevant. So a lot of times when a party makes a logical relevance argument, the judge makes the ruling based on the judge's common sense about the world. And this raises interesting questions. What if your common sense is not so common among the people we're talking about? What if your common sense teaches you that if the police knock on your door and you run away, you must be guilty? That's commonsensical to the Supreme Court, but is that commonsensical to people who live in neighborhoods where the police knocking on your door is not always a sign that they're just hoping you to help out, right? Or that they really want to find the truth? That's an issue. But common knowledge is going to determine the admissibility, the logical relevance of flight evidence, which is something we'll talk more about later. Okay, but enough political content. Let's go back to the logical relevance arguments. Let me teach you about the difference between direct and circumstantial evidence. And I do this not so much because this is legally important, as this is a really important issue to understand in the communication from the courtroom to the public, because oftentimes, as I said before, the public will hear that something was nothing but circumstantial evidence, and that's supposed to be an indictment of the evidence, when it really isn't at all. Circumstantial evidence is just evidence in which you have to use the logical relevance approach. So let me explain that. Here's the evidence. I saw the defendant speeding at this point. Okay, and I want you to imagine that this dotted line, very elaborate graphic here, is a highway, and that it's 33 miles long. Okay, can you do that? So 20 years, 30 years from now, when I do this, I'll have these little racing cars, 3D racing cars, and they'll be projected on holograms across the classroom. And then they'll be up here, right? The only way we'll be able to keep your attention. Some of you may take off your headphones for a second just to watch the demonstration and learn a little bit. And then you'll be right back on to your blogging and your internet. Anyway, this is what we're trying to prove, right? Defendant's speed at the time of the accident. Notice that we have to make an inferential leap, and that inferential leap is what gets us from the evidence to what we're seeking to prove. Okay? Good general rule. When an inferential leap is required for relevance, logical relevance is at issue. Okay? When an inferential leap is required, logical relevance is at issue. Okay. Well, this graphic hopefully makes it easy for you to imagine a situation in which logical relevance is not an issue. How could you change the evidence to reduce the inferential leap? How can we move the eyewitness from 33 miles away? Making it hopefully very obvious, right? All we need to do is have a witness who saw defendant speeding at the time of the accident. Okay? Is there a logical relevance issue? Well, be careful. If you think carefully, you can't think of a problem. If I say, are all inferential leaps eliminated by testimony of this sort? Are all inferential leaps eliminated? Is there anything that we have to infer about the evidence in order to conclude that defendant was in fact speeding at the time of the accident? What's the difference between this and this? Whether the witness is accurate or not. Okay, whether the witness is accurate or not. So all the inferences are removed except the inference that the witness is accurate. Okay? And what it turns out to be the case is that when the only inference required is that the witness is accurate, the evidence is what we call direct evidence. Was there direct evidence of the defendant's negligence? Yes. Someone saw him speeding at the time of the accident. Was there direct evidence of the defendant's negligence? No. Someone saw him speeding shortly before the accident. Oh, so you mean it was just circumstantial? That's right, because I have to make the inferential leap that because he was speeding before the accident, he was speeding at the time of the accident. Now, all of a sudden, direct evidence doesn't sound so great, right? Because you've got to trust the witness. And one of the things you learn, particularly if you do law and psychology, is witnesses cannot be trusted. But that is what direct evidence means. And when an additional inferential leap is required beyond simply believing the witness, The evidence is called circumstantial. Okay. Now, here's the funny thing that I've referred to earlier. What is the difference between direct evidence and circumstantial evidence? Traditionally, direct evidence is considered superior because the inferential leap. Courts and people will say, well, you have to make all sorts of assumptions. You have to assume that he maintained the speed, right? You found some identification evidence, okay? But you have to assume that that identification evidence really belonged to him. Well, DNA evidence comes along, and it turns out that there is an inferential leap, but we can prove through statistics that the inferential leap is very, very safe, right? It's very, very likely. And in fact, it doesn't take you too much to imagine situations where circumstantial evidence might be superior to direct evidence. And the reason is because direct evidence still requires an inferential leap. And what is that inferential leap that direct evidence still requires? That your witness is accurate. So all you have to do is to pit the uncertainty of circumstantial evidence, the inferential leap, against the uncertainty over the accuracy of the witness who testifies, say, I saw him do it. And if you very much doubt the witness who presents the testimony, the direct testimony, if you doubt his or her credibility or accuracy, circumstantial evidence can easily make a stronger case than direct evidence. Okay? Now, sometimes you may or may not believe the witnesses, but we've got cases now where you have believable, clear, credible eyewitnesses who continue to persist in saying, I saw him do it, he is the killer, but DNA evidence has exonerated them. And we're now in a position where even very once thought credible eyewitness testimony is thought inferior to circumstantial evidence, DNA identification. Okay. Ironically, it probably is the case that the major difficulty with DNA evidence is not in the technology, not in the inferential leap of identification, but in the credibility of the witnesses who testify. Because they are people, and they cut corners, and they make mistakes, and they lie. And as long as we have to rely on a human at some point in the process, we'll never be able to be totally sure of our judgments. So the robot world is coming. Yes? Yeah, usually, you certainly don't have to make an inferential leap as to what it really says, but you almost always are trying to make an inferential leap from the words in the document to what you're seeking to prove. So, you know, imagine you have a witness's deposition saying, I saw him speeding 33 miles west of the accident. You're no longer uncertain about whether the witness actually said that, but you have the inferential leap built into the statement in the document. So don't think that documents solve many problems of relevance. Documents will solve other sorts of problems, like did the person really say that? And that's a different issue than what we're talking about now. Okay. All right, that's direct evidence, circumstantial evidence, materiality, logical relevance. We're going to talk a lot more about logical relevance because that difference between the general and the specific is going to be important when we get to conditional relevance. And it's also going to be important when we get to the division between common knowledge and what science might be able to demonstrate. So there's lots more to talk about. But for now, let me move to 402 and give you a nice, easy rule to look at. All relevant evidence is admissible. Isn't that great? Oh, there's always something. Except as otherwise provided by the Constitution of the United States, by acts of Congress, by these rules, or by other rules prescribed by the Supreme Court pursuant to statutory authority. And what I want you to write is, relevant evidence is generally admissible. Even if you were handwriting your notes, I would be easy on you, right? And what you want to do is stop and look at these authoritative sources. And you want to ask, well, what source or sources isn't or aren't mentioned? One thing you'll notice is they don't mention your favorite kind of law in your first year. Is it? Well, let's take a vote. Who likes statutory law better Who likes the common law? Yeah, we're still a common law crowd. And the ones who didn't vote, you hate it all. Or you love it all. Or whatever. Notice that common law isn't mentioned. Notice that another friend of mine, state law, isn't mentioned. State laws are generally out of the picture. And this, of course, raises eerie questions. And I don't mean, ooh, eerie questions. I mean that old chestnut Erie versus some big corporation that you learned about in first year civil procedure. They still teach Erie, don't they? Yeah, just a little, because it really doesn't matter very much. There's a distinction between substantive and procedural that we'll talk about more. For now, though, relevance is what you want to understand. And we'll come back to common law and state law at various points in the course, including, remember when I said Congress decided to scrap the privilege rules? Does that mean they don't have any privilege rules in the federal courts? No, they use the common law, okay? Does that mean they don't have privilege rules in state courts? Well, of course they do. The states have their own rules of evidence, but the issue, of course, is always in diversity cases where the federal government, the federal courts are trying to apply state law. There often comes up the issue of, well, wait a minute, look at this state law. Is this a state evidence provision, in which case we don't apply it, or is this a substantive state policy, in which case we do apply it? And that creates for some interesting issues. Not interesting enough, though, because what I'd like to talk about, and here's where we'll stop the recorded part, is I want to do a couple hypos to